Okay, welcome to Chapter 11 of Gaines and Miller, Criminal Justice in Action. This is continuing our examination of that text published by Cengage. The authors are Larry Miller and, oh gosh, I think it's Roger Miller and Larry Gaines. It's a Cengage publication. And this is for North Carolina Criminal Justice course uh, at Wake Tech, Introduction to Criminal Justice, CJC 111, all chapters. Okay, we're recording this in June of 2022, and we are starting a new unit. These next few chapters are going to be focusing on uh, beginning to focus on, it's a transition really from the courtroom to prison and jail. So this is kind of a bridge chapter. I think you could really put it in either of the two. I think technically it's still in the one on the courts. And certainly we'll talk about the courts and sentencing, but it begins to introduce us to the ideas of what do we do when we actually have someone convicted here of a crime. Okay, so obviously there are a few questions as I usually ask before you begin studying a chapter. And some of these, when I use them in class, I get some very interesting answers, particularly for this first one. One of the questions, or one of the ways to frame when you talk about punishment, is is punishment a goal or is it a path to a goal? Another way is it a means or an ends? Sometimes you hear it described that way. So why do we punish? And I think it's one of those skip steps we talk about. We talked about the skip step in the very beginning of making something illegal, deciding that the first step in criminal justice is not the commission of the crime; it's the definition of the act as a crime. Well, really, the first step here is the decision that we have to punish people. Um, the second question I think to examine is what is effective punishment, and I think that's going to relate to the first one. I think that we will all acknowledge that human beings are almost infinitely variable. That for some people, the worst possible thing is to be locked up. For others, they're adjusted to it. To something, people, corporal punishment would be the worst thing ever. For others, temporary infliction of pain would be not as bad. So, since there's a variation between people as to how they react to punishment, why use a one size fits all? Raises our third question to examine here. What alternatives are there to incarceration? Now, the primary mechanism that we use in America for punishing of any sort of serious offense is we lock people up in jail, restrict their movements, put them in with others. Um, what alternatives exist? Throughout time, historically, other societies have looked at things like banishment. Um, there's some classical allusions to that. The Athenians would banish people, and actually, there's biblical allusions to it as well. Uh, there's corporal punishment or physical punishment used to be much more common. Should everyone's punishment be the same? And why are the reasons you're varying it? Is it varying between what the victim is like, what the crime is, what their gender is, or their victim's gender? Um, the victim's age and their age. I mean, these are all things that vary punishment, and the question is why. If you have someone that's dead, does it matter if why they were killed by someone? Does it matter how old they are when they die? They're still dead. Does it matter their gender? Does it matter their race? I think these are all good questions to ask. Okay, again, we have our classic learning examples that you're probably sick of seeing, and me telling you that these are not critical for you to know going through the lecture of this chapter, excuse me, but they are critical to the course, and they introduce what we're trying to accomplish. Okay, so your book starts off with the kind of classic four, I'd say. These are the four most commonly stated reasons why we punish people who commit crimes. And quickly they are retribution, deterrence, incapacitation, and rehabilitation. So one at a time. Retribution is, I guess, probably most familiar to us in that old adage, a biblical adage, an eye for an eye or tooth for a tooth. That you balance the scales in some ways. That someone that harms somebody else is themselves harmed. And that you restore a sort of justice. And when I say eye for an eye, tooth for tooth, that is an Old Testament allusion. But you can go back and you read the code of Hammurabi, or you can talk about karma in Indian philosophy, I guess, Indian religion, if you will. It's a pretty common idea that those who commit criminal acts should be punished according to the severity of their crime. You're looking for a balance. The second reason, deterrence, and we're going to speak a little bit further on this when we talk about general versus specific deterrence, but you punish people so that there is less future crime. Incapacitation, I think, is kind of a default position where you are preventing, you are deterring by removing the individual from society. There is a concept in psychology called the other, in which one of the ways in which we can treat people not as people but as objects or means to accomplish goals is to identify them outside of our community, to say that's not one of us, so we can do things. And we do this all the time. You'll hear people say, well, it's not America's business to feed people in other parts of the world, or it's not my job in North Carolina to take care of people in California, or it's not my job in Raleigh to worry about what goes on in Durham, or hey, this is my neighborhood, what happens over there, not my problem. And then down to the microcosm, what happens in my house is my business, what happens in my neighbor's house is his. And you're identifying that as another and denying they're part of your community. The fourth is rehabilitation. This is something that waxes and wanes, in which we have more or less attention to it, but it's basically trying to break this pattern of criminality, to make people better, to fix them, if you will. Okay, now we can also talk about a different approach, restorative justice. Restorative justice, you punish because you're trying to repair the harm, hence the term restore, that was done to the victim and to the community. So it's not focused on punishment. And the victim very much remains the center of the resolution of this problem. So one of the things you do here is you give or you get the offender to take responsibility. The offender and the victim interact, so their wishes, their desires very much drive much of this, and the community is involved. The community addresses the crime. And one of the things you do, and this kind of goes to that rehabilitation, is that you're trying to find the problem that led to the crime. And hopefully that solution so there's no future problems. All right, I said that we would talk a little bit about deterrence, and there's really two types of deterrence. There is general deterrence and specific deterrence. So, there's a kind of famous quote about hanging horse thieves. I believe it's from an English judge, and he says, the reason we're hanging you is not because you stole the horse. The reason we're hanging you is that so people in the future won't steal horses. So deterrence can be general. You can show that example. You can say, we're doing this so that everybody else sees your punishments, see how bad it is. You set the example, the deterrent example for everybody else, and you, serving as this example, prevent future crimes through your punishment. That's general deterrence. So punishment is an example. People avoid crime because they see what happens. Now this really embraces that first theory we talked about, the rational choice theory. Why do people commit crimes? They choose to commit crimes. How do you stop people from committing crimes? You make the choice of crime bad, difficult. Um, Specific deterrence is a little bit different. Specific deterrence, you're trying to keep that particular person from committing a crime in the future. And there you're not focusing on setting example to the general public, you're focusing on that person. And that can be treatment for that individual in some way. It could be more rehabilitative, or it could be isolation, the removal from society of that individual because you're worried about them. So general deterrence, specific deterrence. There are some alternative reasons to punish that I guess should be addressed. One, it supports the current social and political order. So it reinforces how society is structured. The reason that you punish this group or this individual is that they are going against what the larger society wants. So take, for example, two drugs, the drug of alcohol and the drug of marijuana. Um, One is legal, one is illegal. By making alcohol legal, we support it. We embrace it in many ways in the society. By making marijuana illegal, we support the social order against it. It has little to do with the relative harm of each or the relative danger of each. It has to do with what the social order is, and to some extent the political order, because if you think about the people that would routinely smoke marijuana, I think your stereotype would be someone who was young. Um, and if you think about the people that would routinely drink, now I'm not going to deny that young people drink, but if you think about people who drink but don't smoke dope, I would assume that that would be older people like my generation. Um, so you can see how the law there and the punishment for smoking marijuana and the not punishment for smoking or for drinking alcohol reinforces the society. You can also make money. Punishment can be profitable. The criminal justice system does exist to some extent, okay, to punish, and private groups running this punishment can make money either through labor in prison, using the prisoners who are being punished, or through the very existence of a private prison. Or even if we look at a public prison, the people running it make money. The guards, the corrections officers get a salary. Um, and then I think this third one is the separation of prisoners reinforces the segregation of race and class. If you look at the people who are in prison, it's predominantly people of the lower classes. Now, that does not mean to say, and I would be the first to reject the idea that people in the middle class or the wealthy don't commit crimes. They absolutely do. The question is, why don't they wind up in prison as much? And I think there's a plethora of reasons we can look at there. But one of the things punishment does is it allows us to say, again, those are the others. They're not like us. They're bad, I'm good. And some of that has racial connotations, some of it has ethnic, some of it has class connotations. And sometimes you just have to teach the elephant a lesson. This is one of my favorite slides, and I use this kind of as a shock. Now, indeed, that is a picture of an elephant being hung. In 1916 in Tennessee, an elephant killed its handler, and Tennessee applied the death penalty to the elephant. Now, this is both kind of tragic, a little bit sad, I think, but I think it actually shows quite a bit about punishment. Why would you kill an animal that killed its trainer? I mean, why is the punishment for that, the elephant? Well, first of all, is it going to deter other elephants? I don't think so. I don't think, first of all, I don't think they let other elephants know they did this. So, I mean, it doesn't have this sort of specific deterrence. We could eliminate that. It doesn't isolate the elephant. I mean, we still have elephants going through our society in zoos and in circuses and such. So, it's not going to rehabilitate. It's not going to deter. It's not going to isolate. It's retribution. um, by God, they were going to, punish this elephant for what it did. And actually, they had to use two cranes. That's a railroad crane that used to lift up railroad cars in 1916. They, they, I think, as I recall, and it's been a few years since I read about this, the first crane they used broke, and they finally got another crane, and they basically lynched an elephant. Um, okay. The structure of sentencing legislative. Having decided something is illegal, so pick whatever you want, whether it's something very, very minor like jaywalking, or rolling through a stop sign, or it becomes more serious like simple assault. I punch someone, or assault with a deadly weapon. I hit someone with a board, or very serious. I stab someone with a knife, assault with a deadly weapon inflicting serious injury, or even more serious, I killed somebody. So the legislature will look at those crimes and say, we're going to have to decide in a sort of priority. We're going to say this one, jaywalking, is less serious than rolling through a stop sign, and the stop sign is less serious than simple assault, which is less serious than assault with a deadly weapon, which is less serious than the homicide. And having, first of all, set that order, then the question is, even inside that crime, is should there be a range of punishment, or should everybody be identical? Should everybody that gets convicted of manslaughter get 18 months, period? Or should you say, well, one person did it because he had imperfect self-defense. He was defending a piece of property, or another person did it because they were drunk, but this person did it in premeditation. So the legislature will often set a range of time to be served. As an alternative, though, they might say, no, let's go for that. Let's have a definite time that you're going to be sentenced. But even when they say everybody needs to serve 8 months, or everybody needs to serve 8 years, or everybody needs to serve 80 years, you'll see in almost every system that it's possible, if you go to prison, to get out early if you behave well in prison. And the reason for this is quite simple. If you put someone in a situation where it doesn't matter what they do, but you're going to keep punish them, they won't behave. And the people that are guarding them, the people that are watching them, are going to have a great deal of difficulty controlling them, getting them to obey the rules, getting them not to commit other crimes. But having said that, most truth in sentencing laws require that you serve at least a minimum of 85% of whatever sentence you get. So here are your options, ranging from the very, very minor up to the very, very serious, and of course at the very end, the unique. First one is fines. This is very common. If you go down to district court here in Wake County, one of the things you'll often see is you might get a $50 fine or a $100 fine. So it's very, very common for a crime. That could be for speeding, it could be for an illegal parking, it could be for any minor thing you think of. But you're also going to wind up paying court costs. And that comes as a shock to a lot of people when I say, okay, your fine was $100. Your court cost was $280 or $300. So you can wind up paying more money in court costs than in your fine. And okay, the obvious question is, what's court costs? Well, about a generation ago, government needed money to do things. And they needed money to do things, for example, like pay for police training, or fund the retirement system for the sheriff's deputies, or even some cities and towns needed money for parks or recreation or other TV programs. So the problem with an elected official is it's extremely difficult to raise taxes. It's hard to look to people to say, well, we need to set up a retirement system for our police officers, or we need to set up training for our police officers, and you have to pay more money for it, John Q. Public or Mr. Taxpayer. But what they found out was, well, we can just raise the fees in a courtroom, and the people that are paying it are criminals. They can't object. They're criminals. No one's going to listen to them. And we can get that money. Now, it's not low in North Carolina here, but there are some jurisdictions. I was reading about some of the towns in Missouri when there were some riots after a police officer shot a suspect, and they were reviewing that in these smaller towns, the police did a tremendous number of stops and a lot of arrests and tickets compared to what they did in North Carolina. And the reason was pretty obvious. Up to 60% of the budget of these towns came from these court costs. That, if you think about it, changes the police from an entity that enforces the law and the courts from one that is those goals, rehabilitation, retribution, isolation, deterrence, to really a tax collecting entity. Okay, so the second is probation. Um, Now, people often confuse probation with parole, and parole is a different thing, but probation is the most common sentence for most crimes because most crimes are very minor. Um, so, a crime like public intoxication, which in North Carolina would be drunk and disruptive, you're going to get probation in most cases. Even for something like DUI, driving while impaired, or driving under the influence, DWI, driving while impaired, DUI, driving under the influence, different name, same crime. Yeah, you're going to go to jail for 48 hours usually when you get arrested, but your first sentence for that is going to be probation. We're going to let you out, and we're going to talk all about probation when we get to the probationary systems coming up, but they're going to let you out and they're going to monitor you. The third is incarceration, and this is jail or prison. And again, there's a distinguishing between each of those. We'll go into that in some detail. The fourth most common is death, and that's capital punishment. And we'll talk about death later, but that's reserved for only the most serious crimes. There are some unique ones, but these are exceedingly rare. I don't think we need to talk about them. Things like corporal punishment, which is almost unknown in the United States, and public shaming, which is pretty rare in the United States. Okay, one of the things that goes on for serious crimes is a PIR, a pre-sentence investigation report. So after someone is convicted, and sometimes they do the groundwork for this before, but after someone is convicted, the judge might ask for a pre-sentence investigation report. So suppose he's got a teenager who has been accused of a crime. I suppose it's burglary or something like it. He might say, I want a investigation of what this teenager's home life is like. If I'm going to give him parole, I need to know that his parents might watch him, that he's got a stable home environment. On the other hand, if I find out, well, he's homeless, he lives with a step parent who ignores him or is abusive, that's really going to shape what the judge is going to do. So these PIRs give the judge information about their criminal record, their employment history, are they supported, and here's a big one, addiction. Do they have an alcohol problem? Do they have a drug problem? Again, typically used for felonies. You're not going to see this for minor crimes like jaywalking. What impacts sentencing? What things decide how much punishment you're going to get? Well, the first thing I think you look at is how serious they are, and society assigns a relative value to them. You have very minor crimes like speeding, you have very serious crimes like rape. So one of the things there, if you catch someone speeding, you're going to assume that you're going to fine them. If you catch someone who's committed a rape, you're talking about incarceration. The second thing that impacts it is it worse? Does it go beyond even the standard crime? So in North Carolina, and most places, we call these aggravating factors or aggravating circumstances. So let's take, as a good example in North Carolina, the crime of kidnapping. Now, North Carolina has two levels of kidnapping, first degree and second degree kidnapping. Now, if you looked at the statutes, they're basically identical except for the last element of the crime. They all say something essentially like, did you take someone, transport them? It's called an asportation. Did you hold them? And then it says for first degree kidnapping, did you beat them, rape them, hurt them, stab them, kill them? Okay. Second degree kidnapping says, did you do none of those things and did you release them in a way that they were safe? So if you beat someone you kidnapped, rape someone you kidnapped, stab someone, hurt someone, enslave someone, those would be aggravating circumstances for kidnapping. That's going to make your penalties much higher. The alternative is mitigating. Did you kidnap someone, but did you not harm them? So, I mean, I think there's a difference between you kidnap someone to rape them and you kidnap someone because they're your child, and you were being denied custody. So, and you took them to Disney World. So obviously, yeah, you committed the crime, you're not allowed to have custody, but it's a mitigating circumstances. You cooperated, you confessed, you didn't harm the child. Aggravating circumstance, you raped that person, you stabbed that person. The other final thing to talk about is, what's the judge like? The judge doesn't have absolute discretion in almost any system anymore, but some judges are, if you use the very old term, they're hanging judges. These are judges that want retribution. These are punishment judges. Other judges have a different philosophy. They're more interested in rehabilitation. So I've seen this particularly for juveniles. So you might have a judge here in Wake County. Famously, we had a judge named Jerry Leonard who spent a lot of time, if it was a juvenile, and he really tried to help juveniles. And then we had judges that were the exact opposite. I'm thinking of Judge Renfer, who she was very harsh in her sentencing. So judicial philosophy plays a big role. All right, now let's talk about North Carolina structured sentencing. Starting in the 1980s, we actually started first with drunk driving, because there was a big campaign against drunk driving in the 1980s. But starting in the 1980s, first with drunk driving and then transitioning to all crimes, we created structured sentencing. And you're going to see the matrix in just 1 second. But basically, the first thing we did is we took all the crimes. At the very top, we had murder. Okay, murder in the first degree, homicide. Okay, and at the very, very bottom, we had the least serious felony you can think of. And it might, or the least serious misdemeanor, although we have a separate chart for that. So it goes all the way down to simple assault. So your felony will get an A, B, C, D, E, F, G, H, I. The only A pretty much is first degree murder. Stepping down from that, we have the B's, and we actually have a B1, B2, but we have the B's, which would be something like second degree murder. And then you go to C or D, and you might have voluntary manslaughter. And then E or F, and one of those might be involuntary manslaughter. So we establish what your letter is for your offense. And then we decide your past history. And there we're going to give you a Roman numeral from 1 to 7. 1 meaning you have no past criminal history. And so you'll see this matrix in 1 second. And the final thing inside that is we look at your mitigating and aggravating. So let me jump forward, and you can see this is the matrix. You'll see that over there on the left-hand side, we've categorized your crimes as A, B1, B2, C, D, E, F, G, H, I. So A, you'll notice, most important, that's first-degree homicide. And then, it may not be, but jump down to kidnapping, that might be C. Or secondary kidnapping might be D. All the way down to I. And you'll notice there's numbers there. But we also have to determine your prior record level. What crimes you committed in the past. Roman numeral 1 means you have no crimes. You never committed an offense prior to today. That's the most lenient. Roman numeral 6, you're a bad guy. You've committed a lot of offenses. You have a very high criminal record. As you move to the right on the chart, okay, the sentences get higher. As you move up on the chart, the sentences get higher. So the worst of the worst, now for murder, there's only two possible penalties in North Carolina if you're talking about first degree murder, and that's the only Class A we usually look at. You either get death or life without parole. But if you look at the worst of the worst, that would be a B1 felony, so that would be something like first degree rape. And if you have lots of prior record levels, you'll notice that your the worst possible outcome is life without parole, but your standard sentence, which is that gray bar in between, is 386 months to 483 months. That's 40 years. 40 years and 3 months. Now contrast that all the way at the beginning. If you'd committed no previous offenses, even though you committed a horrific crime, your standard sentence is between 192 months and 240 months, which is 20 years. So your sentence doubles. And that range, by the way, again, is there to control you in prison. If you don't give the ability to say, okay, if you behave in prison, you'll get out early, you'll get out in 192 months, then how are you going to control them? So if you look at that, if you look at a box, let's look at the box, say, offense class C, okay, and let's look at prior record level 2. You'll know, first of all, it's got a little A above it, which means it's active, and it says 77 to 96 months. However, if you were bad, even with that prior record level and what you did, we're going to bump you up to the aggravated level, which you can see there is the numbers above. We're at C3, I think I said. That's 96 to 120. Your standard range is 77 to 96 months. Your mitigating ranges, if you behaved, you confessed, you cooperated, 58 to 72. So you can see even inside there's a variation. We do then see differences between sentencings. We have what are called sentencing disparity and sentencing discrimination. Disparity. So what's disparity? When people who are convicted of the same crime get different sentences. You jaywalk and I jaywalk. I get a fine, you get executed. That's disparity. Now there can be good reasons for that. It might be your 27th offense. Another type of sentence disparity is I jaywalk, you kill someone, we each get a suspended sentence. Well, we got the same sentence for crimes that are very, very different. One of the things that leads to sentencing disparity is sentencing discrimination. Now, as I said, sometimes disparity makes a lot of sense, but sometimes there's a discrimination issue. Discrimination is when particularly outside factors impact how long you get a sentence for. And one of the things that we know is that sentences tend to be longer if you are poor, if you are in a racial minority, and that would include also ethnic minorities, or if you're a man, and that's one that's not talked about as much. But if you have, I used to years ago teach a course on serial killers. If you look at how female serial killers are treated in our society, and you look at about how men serial killers are treated, men serial killers are almost always executed or held for long periods of time. Women serial killers can be executed, it does happen, but they do have lighter sentences. And I think part of that is rejecting the idea that a female can be a killer, and it's a sort of a discrimination, or it's a positive actually towards women or a negative towards men. All right, so sentencing disparity. Again, different sentences, different crimes, or different sentences for similar crimes, or mitigating, aggravating factors have disproportionate impact. Now, there can be differences geographically. If you look at states in the Fourth Circuit of the United States, which North Carolina is in, some of their felonies have 5-year longer sentences than those that are in the Ninth Circuit of California. Also, there can be differences between federal and state. Federal laws can be much harsher. For example, someone convicted of kiddie porn, it could be just possession, it could be something else, in Montana could serve 2.5 years. Federally, they might have a 30-year sentence. One of the things that you see for politicians, people running for office, is it's extremely popular to say, I'm going to get tough on crime and enact harsher penalties. Okay, let's talk a little bit about race and gender here. Racial impact can be huge. So in New Jersey, which would, not be most people when they start talking about race will talk about the South. They will say, well, the South has this history of Jim Crow, the South has a history of slavery. That's certainly true, but I don't think that there's any part of the United States that doesn't have issues with race. So let's take a northern state like New Jersey. African Americans are 12 times more likely to get a prison term than whites. And that goes up even more, that discrimination, if you are young and if you're unemployed. Now, there can be good reasons for this. I think it's probably true, for example, that the reason more men are in prison for murder is that more men can commit these murders. I think the reason that poor people tend to be in jail is some of the crimes that they commit are just going to be committed by poor people because they need to. A person that has the money to eat, that has the money for an expensive apartment, has the money for food, doesn't have to steal. A person that can't eat will steal. Women is a good example of this, and looking at sentencing discrimination, you can think about women and or men in sentencing in two ways. Either you say men get harsher sentences or women get more lenient sentences. So which is it? Is there this, here is the standard amount of time, 5 years. Women get a year, men get 10 years. In the middle you got the average of 5. Is it that we're punishing men more or we're not punishing women enough? This is well documented. Women convicted of the same crimes than men are much less likely to go to prison. This is called in the field the chivalry effect. Of course, there are some crimes that men are not usually charged with that are charged against women. So, some things are criminalized because women do them. All right, sentencing reform. There's a conflict between the idea that the judge is best or the legislature is best. So sometimes you'll hear like, well, we can't trust a judge to make this decision. Let's set a standard. But I think what you have to, if you embrace that philosophy, and there's nothing wrong with that philosophy, but I think if you embrace that philosophy, you have to acknowledge that, yes, you're taking the discretion away from the judge, okay, because you're afraid it's going to be prejudice or improper influence, but the decision about the sentencing is being left with your legislatures, and they might have the same issue. In fact, they might be more isolated. They might be voting for things you might never know. Should we trust our judges or elected officials to be more responsive? Now, most states have long-term towards determinate sentencing. North Carolina joins the 28 states, which is basically 60% plus of the states in the union that have structured sentencing. The federal government has an extremely strict sentencing guideline. You can sometimes in all of these depart from the guidelines, and this is when a judge says, there's a special circumstance here. Very rarely they can increase penalties. Rarer they can also decrease penalties. It's difficult to do, in part because we didn't want the judges to have this power in these states. We wanted to say, we're not going to trust judges anymore. We're going to trust the legislature. All right. So we have these mandatory minimums as well. We pretty much decided we're tired of judges just letting people off. In the 80s and 90s, we're going to create habitual offender laws where if you have, the most famous example are 3 strikes, you're out. You have 3 previous convictions or 2 previous convictions, you got your 3rd one, you're going to jail forever. This led to a massive population increase in our prisons. So the population soared. Our prison population in the 80s and 90s tripled. Now, lately, I think in part because of fiscal reality smacking people upside the head, we began to realize that this is a very expensive program. And we re examined whether this is wise to have these mandatory minimums. We also began to look at the victim more, and this plays both ways. By the 1990s, victimology becomes more central. We began to see victim impact statements where the victim was allowed, outside of determining guilt, to tell the jury how the crime or the judge impacted their family or themselves. And this put the victim back at the center here. Are they a good idea or a bad idea? Well, it gives them a voice. It can be therapeutic for them. It can let the judge and the jury see what the impact of a rape or an assault was. And it may be critical in that restorative justice idea. It may not be, it may allow forgiveness. Now, the arguments against is it's a very emotional thing. You're letting emotional in. Human beings are emotional creatures. And part of that emotion, and this can be the ugly side, is it can allow prejudice and anger to become the central issue. It also can reinforce retribution. Now, that may be a good idea, again, just like the emotion, but it's going to be more retributive justice. All right, let's talk about the death penalty. Here are the 5 ways in which we execute people in the United States. You've got electrocution. Now, believe it or not, electric chairs started in the 1890s. They still exist in 7 states in the United States. It's the primary execution, though, only in 1 state, and that is South Carolina. Now, when I say primary, the states that have the death penalty, the 27, 28 states that still have the death penalty, if you don't select, you're going to get lethal injection. But there are alternatives. You can adopt alternatives. If you say, I don't want to be executed by lethal injection, here are your other alternatives. First of all, you got electrocution. Second is lethal gas, the so-called gas chamber. This started about 30 years after the electric chair, and it was seen as more humane to strap someone in a room and fill it with toxic gases, let them breathe them in and die. I think probably this came out of the First World War, a lot of it, where chemical warfare was introduced. Now, hanging has a very old history. It was the primary method of execution in the Western world for a very long time, still pretty common. But it's been abolished in most states. Delaware, I think, was the last state that actually executed someone by hanging, and I want to say that was in 1996. It only remains an option in New Hampshire, although New Hampshire's kind of abolished it. So it's on there, but not really very common. Now, here's a surprise. Maybe not if you thought about military justice, but the states doing this, that's firing squad. 4 states allow a firing squad as a secondary method. In other words, they have lethal injection as their primary method, but if you don't want that, you can elect a firing squad. Probably the most famous case of this is a man executed called, I believe his name was Gary Gilmore. He was executed in Utah. Utah adopted the firing squad over electrocution, lethal gas, hanging, because as I understand it, and I am not an expert on Mormon theology, Utah is primarily populated by Mormons, and there's influence from the Mormon Church. There is a statement, or there is an allusion in the Book of Mormon, that you atone for sins by literally shedding your own blood. So a good Mormon might prefer, if they're going to be executed, that their blood is shed and then they are forgiven. This is pretty rare. It does happen, but there is the firing squad. The most common by far, including North Carolina, is lethal injection. And this is basically a drug cocktail that you give someone. It first paralyzes them and then destroys their heart. It's offered in 27 states as the primary method, which is most of the states that retain the death penalty. move on. The Supreme Court has never ruled that the death penalty was cruel and unusual punishment because the Eighth Amendment of the United States bans cruel and unusual punishment. However, very briefly in 1972, and I would say this is one of the last potentially liberal cases that was decided by the Supreme Court. The Supreme Court's liberal heyday was in the 1960s under the Warren Court, going slowly into the Burger Court and ending by the time you got to Chief Justice Rehnquist, in which you have the Rehnquist course. But here at the end of the liberal court, in Furman v. Georgia, the court examined how the death penalty was being applied in Georgia, and they said it's pretty arbitrary, it's pretty capricious. You need a standard way to do this. It needs to eliminate a lot of these problems. So we're going to have a moratorium on executions. And this upset a lot of people because they wanted to have executions. So the different states tinkered around, read the decision, and in Gregg v. Georgia, they came up with a method that met the newer Supreme Court because the justices had changed a little bit, and the death penalty was preserved. Okay, this is how it's done. It's called a bifurcated trial. The first stage is we determine, did you do it? If you're not guilty, there's no death penalty. But if you're guilty, we then kind of move to another trial inside your conviction. So we've already decided you did it. Now we decide, should we kill you? That's stage two. So bi means two stage. It's bifurcated trial. First stage, determination of guilt. Second stage, should you be executed? The presumption is you're not to be executed. The state has the burden of proving that your offense was heinous enough that we should kill you. Okay, here is the death penalty breakdown by country and by state. So you'll notice, and we don't have great data during COVID from 2020 to 2022. So by far the most common country that executes is China. They have more than 1,000 executions in 2019. Followed by Iran, Saudi Arabia, Iraq, Egypt, the United States with 22, Pakistan, and Somalia. So you'll notice that pretty much there's no Western democracy in there. There are still a few countries that have the death penalty that are Western-ish. They tend to be Asian. The Japanese, Singapore, Taiwan has the death penalty. But if you look at all of the European democracies, most of the South American democracies, there's no death penalty anymore. The United States, if we look at the raw numbers, there's the Big Ten. Texas, of course, number one. Virginia, Oklahoma, Florida man. Missouri, Georgia, Alabama, Ohio. It's the only northern state that creeps in there. North Carolina is tied with South Carolina for executions, although we've had a real moratorium. You'll notice that almost all of those are southern states with the exception of Ohio. You'll also notice that Louisiana is not on that list, which is a bit of a surprise, but Oklahoma is. Okay, so there are some limits on the death penalty. You can't execute someone that's actually insane. If they're insane when they're being tried or insane when they commit the offense, you can't execute them. You can't execute them if they are severely mentally retarded, and that's usually an IQ issue. Somewhat contentious. There was a big fight about that. The states wanted to execute people that were had very low intelligence, sometimes 70, 80. You can't execute someone who's under 18 when they committed the crime or at trial, and you can only execute people for homicides. You can't execute them for rape or drug dealing. Okay, the debate about this. First of all, it is expensive. Now, this comes as a surprise to most of my students, but it costs you about $700,000 more to execute someone than it does to keep them in jail, just because how complex it is. Is it a deterrence? Does the death penalty keep other people? Our best evidence says no. Or if it is, it's very slight and you can't really see it in the data. Will you execute innocent people? Given the fact that no human system is perfect, I think the answer there has to honestly be yes. Some percentage of the people executed, different numbers might be, as if we look at our DNA exonerations, I would say your minimum number is going to be 10 or 12%. Is it arbitrary? I think the answer there is that yes. I mean, you have, again, some very heinous killers, some serial killers, for example, Jeffrey Dahmer, who was a serial killer who was also a cannibal, um, didn't get executed. Then you have people that get executed that have only committed one murder. Does it discriminate? Again, you're far more likely to be executed if you are poor, if you're male, or if you're a member of a minority group. All right, what's the future of the death penalty? Now, overall, the executions have dropped. We're down to about 20 to 30 a year. That's down from 60 to 70 a year during the 1990s. There's reasons for that. It's very difficult to get the drugs to actually kill people, since lethal injection is the primary way. And as I understand it, the primary drug cocktail relies heavily upon true component drugs, two component drugs that are manufactured, I believe, in Italy and Denmark. Those countries won't export those drugs to the U.S. if we use it to kill people. Um, it's very difficult for countries that don't have the death penalty to support America's death penalty. As for public opinion, it's pretty split. For the first time in 2019, a majority of the public favored having life sentences over capital punishment. But in individual states, those numbers can be reversed. You take a state like Texas, death penalty is extremely popular. You take a state like New York, it just abolished it. All right, I kept it right at 50 minutes like I like. Whenever you're ready, you can go to the next chapter. Have a good afternoon or evening or morning, weekend or day, and I will talk to you next time.